Okay, we are live, streaming through the digital airwaves of YouTube, Facebook, Instagram, and LinkedIn. I am Justin Sterling. I primarily practice personal injury and business law. This is Coffee with a Lawyer. This is your chance to ask the lawyer your legal questions for free. It's our pro bono service. This is why we do what we do, to help people deal with their legal issues, improve their lives, and make a meaningful difference. Again, there is no attorney-client relationship here, no confidentiality. This is important for me to let you know because what is discussed here potentially could be discoverable. You just have to know that, all right? This is for general information, not specific legal advice. Let's keep questions broad, and if you need specific legal advice, we can do a consultation in a more confidential setting. And if I can't help you, I will do my best to get you to the attorney who can. And today we have a special guest. I'd like to allow is it Ellie to ask her question, please?
Yes.
Okay, please proceed.
I was in the process of mediating with a youth agency. I'm the plaintiff and the youth organization is the defendants. Went to mediation and I accepted a huge concession of an amount, very low, just because I did not want my children to go through trial and all that stuff. I currently am pro se. I had to fire my attorney because she did not respond to multiple briefs where she was held in contempt of court. And I was blindsided that she didn't do any discovery on my case. Nevertheless, I went to mediation and like I said, I accepted a very low settlement amount just to get this case over with and have closure and have peace. It's been going on for litigation. It's been going on for 3 years. So once I accepted the settlement, I read the CR2A agreement. In that CR2A, it states that there's going to be a separate agreement for confidentiality and non-disparaging agreement. And opposing counsel.
Well, let's take things slow. All right. I am trying to keep up and take notes. All right. But there are some key significant events. Okay. And I'm sorry for interjecting. It's only because I'm listening with my legal insight and experience. Sure. Let me just throw some thoughts in of what you discussed so far, and then I want to continue from where you left off, because where you left off is a significant event. But you have discussed some issues that are of some importance. You accepted a settlement agreement, essentially. So the terms of that agreement may control. We have to evaluate that first and foremost. Now, you may have an argument here with the ineffective assistance of counsel. Your position is that there was no discovery done. In a 3-year litigation with no discovery done, I would say you have a pretty persuasive argument. Now, I need to dig a little bit deeper as to what was done, what actions the prior counsel did, because the course of discovery is largely discretionary, the judgment of the attorney. Did they take a deposition? Sometimes discovery, just one deposition, may be more powerful than serving a ton of written discovery. I don't know. The case kind of evolves on its own. However, if there was completely no discovery done, that's something that should be looked at. Also, communications. What communications were maintained between the players, not just the former counsel and the client, but the opposing side as well. What was exactly done? Now, ineffective assistance of counsel, legal malpractice actions are complex because you essentially have to also prove a case within a case.
Right.
Which, there's layers to this. You got to show that you had a good case and things would have been otherwise. But for the ineffective assistant counsel, things would have been different. I don't know if that's the situation with what you have already disclosed here, because again, things are discoverable here. Let's be careful of what we say, please. I
Right.
got to make that very important. And that's kind of also why I stopped you where I stopped you. Okay? Because this could be discoverable, what we're talking about here. So let's keep things more general. All right? I hope what I've just discussed kind of gives you some insight.
Oh yes, I already know that, but thank you for the confirmation.
So now we can go a little bit one step further if you'd like. You want to do a follow-up question where you left off?
I did not agree to the terms of the agreement because the opposing counsel is stating that they will not agree to a mutual non-disparaging agreement. And he says that it is standard. And I said, no, I disagree. It is not standard. Usually in settlements, it's mutually agreed upon. And I will not accept this lowball offer for settlement if your client will not agree to the non-disparaging agreement. Essentially, he has put the obligation only on plaintiffs.
I stand with you
as well.
I stand with you.
Is that correct?
I would not have described it any better myself. I stand with you on this. Whatever the terms in settlement agreements, the best practice, and look, every situation falls on its own. Now, they may have the bargaining position here because they're the ones with the resources,
right?
The bigger party,
right?
Bullying the small person.
Right.
Happens all the time. However, fairness, terms should be mutual here.
Exactly.
I think you have a good argument, and I stand with you on this. But how much of a fight can we put up here? What is at stake? Is the dismissal of your case at stake? Is the rescission of this supposed settlement agreement going to be taken off the table? Is it so disfavorable that we want to still continue to assert that there is a voidable contract? I don't know if you signed this document. That's a key fact.
I have not.
Okay. You have not signed.
The opposing counsel has, but I have not.
You have not signed.
Right.
I agree. So I think it's a matter of how much more time you could put up with this and what stage in the process are you? Are you close to trial? Do you want to risk trial, especially being in pro per? Is it a trial? What venue are we in? Washington State, correct?
Yes, federal court.
Okay, again, I'm not licensed in Washington State. I cannot give advice, and this is just general information anyways.
Right. Well, let me just say this. The court has striked the scheduling order. I was prepared to go to trial. I actually have completed law school. I just have not sat for the bar. But just last Friday, the court striked the scheduling order pending summary judgment. And I had made it clear. I also voiced my concern to opposing counsel that I do not believe that this mediation was in good faith because you want me to attend mediation, but at the same time, you filed for summary judgment. And he also mischaracterized my position with the court by saying that plaintiffs need guidance moving forward.
Yes.
I never sought guidance from the court. I was prepared to go to trial if opposing counsel, by way of his clients, did not agree to a mutual non-disparaging agreement.
Understood.
So that's
tread carefully. Tread carefully. How I interpret this is that the court is telling you you need to get counsel now, or they will grant the summary judgment motion. What I would do now, and you're speaking to counsel, you realize this now. Now it's time. You pushed it improper, and I'm not saying you couldn't do it. I'm just saying the courts are disfavored about taking up their time, resources. They view cases from pro se litigants with skepticism. They have a busy caseload. Unfortunately, I wish it wasn't the practicalities of it, but the courts take more consideration into their time above all else. The clock is above the jury pool for a reason, time. And they view pro se litigant cases with skepticism. Now is time.
Right.
You got to get lawyers.
I feel that if he was going to grant summary judgment, the court wouldn't need to strike the scheduling order, because if he grants summary judgment, the scheduling order is moot because the case is dismissed. So there would be no need for him to strike the scheduling order.
Fair. They can always get to the scheduling order later. Okay.
Right. That's what I'm saying. So I feel that he strike the scheduling order.
It's irrelevant. What matters is the motion in front of him, the dispositive motion that can kick your case out.
It's been a while.
Forget about the scheduling order at the moment. You got to address the summary judgment.
Yes.
I don't know when is there a hearing on date for the summary judgment?
No, everything is not even oral argument. I've requested oral argument, and I feel like the judge is ignoring my request as well.
What's on calendar for next?
The pending summary judgment ruling.
Yes. So what I would do, that is a date that can kick the case out, a dispositive hearing.
Right.
So now you need to, when is that date?
There is no date. There is no date there's no definitive date for a ruling, but he can rule any day. But the filing and the briefings were closed in June. I forget the exact date, but summary judgment briefings were closed sometime in June.
Well, you got to take action promptly.
Well, there's nothing I can do.
You need to documents. Yeah, well, you need to get counsel.
I can't do that. I don't have any money. I'm financially strapped. So this case has my loss of income has been over $1.6 million.
Understood. Did you oppose the MSJ?
Oh, of course.
And are you confident? Okay, are you confident in your papers?
I'm very confident that there are material facts that are in dispute.
So then you need to have an adjudication. If you're ready to go forward, maybe perhaps write another motion to the court requesting a ruling.
Well, the court has already stated on Friday that they have stricken the scheduling order pending summary judgment ruling.
What? Request the ruling. If there's no date on calendar, request the date to be heard.
Right.
Continue to request your date and document it. Fully document. You want to document your efforts with declarations now, and it depends on the course depends on the course you want to take. If you want to preserve a record of you having ineffective assistance of counsel, I mean, what are you trying to argue here? More time, or do you want adjudication?
No, I'm just I'm ready for opposing counsel to be reasonable and sign a mutual agreement of his proposed draft, and then we can settle this matter and close out the case. If not, I'm ready to go to trial. I'm ready to have the jury and the public.
Well, that's not going to be your decision whether you go to trial. It's the MSJ right now. So you got to just do the first things first. The MSJ is before the court first. So get a ruling on the MSJ. If you feel confident in it, and I haven't reviewed papers, haven't reviewed the facts, and this is not the setting for that. But you have, either, you feel confident, you got to put some pressure on the other side. You said you're ready for trial. I have no choice but to believe you.
Right. Well, and I feel like the opposing counsel is has misled the court, because
that's for another day.
Okay. He just stated that I needed guidance, and I didn't need guidance. I think it was him that needed guidance. That's why he was saying that. But all throughout mediation, he was basically saying, if you don't accept the settlement, we're prepared for trial. So here in my back of the mind, I'm thinking, okay, well, they're prepared for trial. Then now, once I said I'm not signing, then he contacts the court and says, we need guidance. No, there's no we that needed guidance. Your side needed guidance. My side does not.
Well, the court cannot give an advisory opinion. You're not going to get any guidance from the court.
Right. Well, apparently, no. We did get guidance from the court because essentially the court struck the scheduling order.
Well, they're trying to communicate in a different way by doing something procedural. It's for you to interpret beyond that. I don't know the dynamics here. You know the judge, you know the opposing counsel, you know what they're saying to you.
Right.
But I want to acknowledge Tony is here.
Right. Thank you for your time.
Well, thank you. Feel free to stay on, Tony. I'm sure maybe a different issue, but this is very helpful for everyone involved. And there's some very foundational legal principles here. You got to always know how to handle litigation. This is how we resolve our disputes in society. And contract law, forming contracts, you have to be able to foresee what may happen and know how to handle a dispute, which may end up in litigation. These things happen. So I appreciate you signing on. What I can do is walk you through this because I'm here every Monday, 9 a.m. You know where to sign on. And this helps us address our legal issues first thing in the week so we can attack it head on. I will say more will be revealed. You just have to address what's in front of you right now. Prioritize, even in the course of a lawsuit. Does that make sense to you, El?
Yes, it does.
Okay, Tony, may I be of service today? Can you hear us? Mic check.
Hey, Justin, how are you?
I'm doing well.
Real quick, I know you're running out of time. You know, Sky just closed the deal with Paramount. I was saying, what if you had like a script that was optioned or bought by Paramount and it's in development hell now? What kind of legal ramifications will take place if, you want the script back so it's just not lost forever? What can you do?
Interesting question. Well, copyright. I was thinking of you a few weeks ago. Remember, we were just discussing about copyright and an artificial intelligence in a script. I just want to backtrack. It's a little off topic, but I wanted to clarify something. When you copyright a script and you use some AI, you may have to disclaim the portions of AI and only copyright the portions of that script that you in fact wrote. Does that make sense? Because I know that's a hot topic. We've been discussing it for a while.
But the Copyright Office, I don't think they have an option where you can indicate that it was written partly by copyright. So do I just submit to the Copyright Office only the portions that I wrote?
No, I believe there may be some portions in the electronic copyright application where you can disclaim. I'll have to look at it again, but we can come back to that. All right? But just be mindful of that. You may have to indicate which portions were AI generated and which portions were in fact that you were the author of. I would say depending on how it was used in the course of the creation, okay?
Yeah.
It's still, that area that's still developing. AI is coming on like a boom. All right. But let's just keep that on our radar. All right. Let's take a look at the copyright electronic application and see the boxes. I haven't visited the site it's been a while, but I've been informed by other entertainment counsel that this is how they would handle that.
Okay.
So, but back to your question now with Paramount.
Okay.
So what's going on with that?
So, Skydance just bought Paramount and closed on a deal. Suppose you had a script, with them that was, bought by the one regime, that would be Brian Robbins. But now that he's out, it's in development limbo. How could you fight to get that script back and to resell it so it's not lost forever? Well, I heard that happens often.
Right. First, every dispute or potential dispute, you want to handle it with good faith and clean hands. So the first step I would do would be to document my efforts to what we call requests for adequate assurances. Because they got contract rights, the production company, there is an agreement here of some sort. And again, I'm not a part of this deal. I don't know the terms. I don't know what was negotiated, but I'm assuming there's some deal here and it has reached a stalemate without going forward. So first we have to document our efforts to hold them accountable to their duties and request what we call adequate assurances. And they have to put it in writing that, yes, we're going to go forward. And we can ask for reasons why it has not gone forward. If there is, in fact, some material breaches, ultimately, the recourse would be to sue for breach of contract. But we want to build our case. Okay, I believe this. You're giving me a real life hypothetical. This is something going on at the moment. I haven't been following the news, right?
Well, I don't know. I mean, I heard that's what usually happens when studios, change the guard.
Yeah.
And, they get rid of their management. The scripts that they bought are in limbo, and sometimes they just don't get made. So it would be, you may want to get that script back and get the rights back for that script from the studio so you can probably resell it, right?
Well, you would want to try to make some type of argument of that the contract is voidable, that this was presented to them under misrepresentation, false pretenses. And sometimes that would take discovery, filing a lawsuit and getting discovery into internal workings as to what was the real intention of the parties. Was this something to just buy and then just shelf? And I know the new guard may get involved, and then ultimately the recourse would be a breach of contract, and then maybe seeking what we call specific performance. Specific performance is a equitable remedy where the court orders them to perform something, but it has to be somewhat unique. So you would have to argue that the services are unique. But at that moment, the relationships and contract law and business dealings, entertainment law, or in any industry is about relationships and relationships of trust. And I would say at this point, the relationship has been so tarnished of disrepair. So arguing rescission of the contract and putting the parties in a place had they not entered a deal and restoring the intellectual property rights to the rightful party. That would be the ultimate recourse. Legal proceedings, that's how you would handle it. Can you get the rights back to a script? It depends. Like every situation in the law, it depends. It depends on good lawyering, which I think we will see. This is a case that maybe we should follow and see what happens. This is against Paramount.
No, it's not against anybody. I'm just saying hypothetically, if I had something, you know, across the headlines that Skydance, taking over Paramount, I would just, asking a question as to what can happen because I'm sure they bought a lot of scripts and they're buying more, scripts and IP.
I would write
right
to,
now.
I would, well, it depends also on the objective of the screenwriter. Do you want to get this script back or do we want to go forward with the project being made? Because we can document our efforts to have Skydance continue as the signee of this agreement. They're under contractual duties because they took over the business and all these contracts. And we have a contract for you to produce this project. Request them for adequate assurances. Are we proceeding here? Let's be clear. Does that make sense?
Okay. Yeah, it makes sense.
And
I
if
just wanted to, just get an idea
yeah,
what can happen. That's all.
and if there's been some obligations under this contract that have not yet been performed. Let's bring it to their attention. Let's let them know that this is material, and we got to give them a chance to cure the relationship, fix it. Let's do these. You're under a duty to do this. You are under a duty to bring capital by this date. Let's do it. We can give you the opportunity to cure this by providing that capital within 2 months. We should be in post-production by this date pursuant to the contract. We're bringing this to your attention. This is a material breach. We are allowing you the opportunity to cure it by potentially, maybe we have to enter a modification. If not, then you will have no choice but to bring a breach of contract action. And you can seek your expectation interest. It's all about damages, recoverable damages. You may not be able to get the rights back to the script, but maybe you can assert damages, money damages. Understood?
Correct. Yeah. All right. Just wanted, that's where I am, and see where this can go. That's all. Any thoughts on a merger?
I'm not familiar with what's going on. I mean, maybe you can enlighten me. There's in the entertainment industry, I have not followed the news, unfortunately. What's going on?
Skydance just purchased Paramount Studios.
And this is a big transaction. I'm sorry. I have, like I said, I've been involved in some other legal matters that have been taking my focus.
Okay.
But
yeah,
it's Skydance is just taking, that is a huge takeover.
For $8 billion. I think it was $8 billion.
So does that mean everything Paramount, their whole library?
Yeah, everything Paramount Global. So I think it's CBS, Paramount Studios, the television, streaming Paramount Plus. I think CBS Sports as well.
And who's
Sport UFC?
Who's behind Skydance?
David Ellison. David Ellison is CEO, and Jeff Shell. Jeff Shell from NBC Universal is the president.
Yeah, this sounds like it was a big deal. Yeah, I have not been following the mergers. I mean, that type of deal is probably beyond my practice, but it's going to trickle down and affect everything. So it's something that we should definitely be aware of and keep it on the radar, especially industry professionals such as yourself. And you're right. I mean, if you have some deals with Paramount that was in the works, I would request adequate assurances. Let's honor these deals. Everyone's entitled to the benefit of their bargain. And if they're taking over their business, this is something that continues.
Yeah.
That's what I would argue.
All right. So, I don't want to take any more of your time. I appreciate it.
Well, it's good to hear from you. I appreciate both you guys signing on today.
Can I ask just one more question?
Sure. Before we adjourn?
Yeah. Well, I just wanted to know, I could probably secure some money to retain counsel. If I do that, would you be willing to locate?
We can take this
counsel for
yeah.
I believe that I can still probably settle the settlement, but maybe I need an attorney to knock some sense into this opposing counsel to let them know that mutual settlements are usually mutually agreed upon.
Perhaps this is something that we can take offline and I can email you directly. I do have a large network. I could put a referral post out there and perhaps you'll get some contacts. Again, this is outside my practice area, the jurisdiction of Washington State. I'm in California, headquartered in California, licensed by the state of California. But like I said, I have a large network that perhaps I can reach out to. So let me see if you could email me directly at Justin, Justin, at thesterlingfirm.com. Maybe a slight brief description of what you're looking for, 3 sentences that I can put out. And I will also please remind you guys that this is pro bono here, not confidential. And if you're happy with what we discussed here, I know we don't get completely into the weeds of the details, but if you trust me as a lawyer and you allowed me to help you as a friend and a good person, please leave a positive review. I know Tony has left a review in the past, and I really appreciate it. I'll put a link in the chat if you want to copy it. And then we're signing off here on streaming. Thank you.
All right, thank you.
Take care. Take action. Bye-bye.